Welcome to Wills, Estates, and What Comes Next, Probate Insights with Jamie Cuzmar.
Welcome to Wills, Estates, and What Comes Next, where Florida families get clear, compassionate guidance through estate planning and probate. I'm attorney Jamie Cuzmar, founder of Cuzmar Law. I help families across Central Florida protect what matters most with legal planning that goes beyond the paper and meets people where they are. So today, I'm joined by Elyse Salley, founder of Serenity Family Solutions, a friend of mine as well. And we're together here to talk about how mediation, divorce, and custody changes can potentially affect your estate plan. So this is also episode 8. Thank you for joining us. Elyse, good afternoon. How are you today?
I'm well. How are you? Thanks for having me.
No problem. Thank you. It's a pleasure to have you on the show. So, Elyse, let's start off with something basic. Could you explain what family mediation is and how it differs going through the court process or the court system?
Yes, absolutely. So this is something that I love. Out of all the services we do, it's the one that we do the most, and it's the one that I work on and try to just frame the most to be this really great service. And so mediation is a voluntary process, meaning that you can do it at any time. You don't have to have a case open. What we do mainly is work with families who are in that pre-suit state. So they don't have a court case yet. They're just deciding that they want to change their family, whether it's divorcing or paternity, meaning that they have children together but they're not married, or also coming back to us to modify something, either child support, parenting plan, parental rights, or something like that. So we have these families, they're just getting started, usually straight out of counseling, church, whatever it is. Oftentimes just one person is coming in and they're ready to start the change, but they haven't told the other person. And so we just let people know that this is a very amicable and oftentimes how we've made it court-free scenario. So we try to cut out all of that adversarial back and forth litigation. And that's kind of a blunt in communication, honestly, too, because if you're communicating through attorneys, you're not having effective communication oftentimes. So, yeah, I feel like I talked around that a lot, but it answered your question, too. I
Yeah,
guess
yeah,
this whole time.
exactly. I can talk about estate planning all day as well. But a fun fact, I went through a child custody situation many years back with my firstborn. And you don't know what you don't know. So I like to get this information out there to help families because one assumes that you have to get a lawyer if you're going through a custody or a divorce, and that's not always the case. Like you mentioned, mediation is an option, and most people don't know that they can start with a mediation. They don't have to have it court ordered. You can start with mediation, especially if you want to keep things amicable. And what I found out in my own personal experience was that it was the mediator, after we had both already lawyered up, that helped us meet somewhere in the middle and get the parenting agreement that we were going to end up with probably anyway. So lawyering up is not always the best option. I definitely suggest to people that reach out to me with that question, hey, take a look at or consider mediation, because you'll save quite a bit of money instead of fighting it out and spending time in court and needless expenses. So kind of getting back to you, Elyse, what inspired you to focus your career on helping families through mediation instead of like a litigation?
So, like you, it was my own very tough personal case. I worked as a behavior analyst doing applied behavior analysis, mainly in homes for about 8 to 9 years. I started that in 2013 before I switched over to this. And I went through a paternity case, meaning that I have a child with someone who I'm not legally married to, and it's a 4-year-old, and we've been in court for 4 years. A standard paternity case is going to be about 20 filings, so 20 pleadings, and ours is close to 430. We just recently got our final order from the judge after a year, and he felt strongly enough about that type of litigation that there's a clause in the order that says it's the worst case he's ever seen. So when I say that it is a bad case, I now have something that I can prove that with, of the judge actually saying this is the worst thing I've ever seen before. And I fully agree. And there are a lot of high conflict situations that get stuck in the pattern of litigation. And that's where we've started. And that's probably not hopefully, obviously, but probably where we're going to end because we have never sat down and spoken to each other. We only communicate in court. So this is the worst thing I've ever been through in my life. And I wanted to provide these services and create 2 Hour Divorce to give families alternatives that are going to keep them from what I'm going through. So it's very personal to me. And it's, yeah.
Yeah, no,
Need
I think it's a huge and valuable service because although my case didn't go on as long as yours, it was still, 2+ years in my situation. Like you, it was the worst experience I've ever had to go
Yeah,
through as well.
right.
So, speaking of divorce and custody changes, how does a divorce or custody change affect a family's planning, and why does it often mean, you know, that the estate plan needs to be updated? So that's kind of a two-part question. On your side of the fence, on the mediation, how does a divorce or custody change possibly affect a family? Do they have to do a modification, or can they request a change in the parenting agreement?
Yes, they can absolutely request a change at any time. And
Mhm.
if both of them are willing to mediate, then they can make those changes at any time without having to go to court to do so. They're just getting their updated documentation that then does it in their order or their parenting plan or whatever it is. And when we're reopening that, or if it's something that's just ending, like a divorce, then oftentimes we're talking about life insurance and what's going to happen with the will or the trust and everything like that. So when it's on the forefront of people's minds, that is a great time to go back to someone like you and change whatever needs to be changed or establish whatever needs to be established.
So, on my side of the fence, estate planning, it is a good idea for a divorcee to update their plan because it's not, you can't tell whether the divorcee intended to keep their spouse on the will or the trust as a beneficiary or not. You can't ask that deceased person from beyond the grave to clarify for the judge what their intent was. Some divorcees want to keep their spouses on there for the benefit of their children. The spouse can manage the assets for the benefit of the kid. Other times, and it's just every family's a little different. Absolutely, they wanna take the ex-spouse off of their plan, so I definitely suggest, if somebody goes through a divorce or a mediation and a separation, to make sure that their intent is up to date on those documents.
Right. And also to remember that these are separate processes. So I'll have people that are coming into mediation and asking me, hey, can you put it into our mediation agreement that the will is going to change? And I'm like, I can write it in there if you want to, but it's not going to actually change anything. Or even something like a quit claim deed. Something is happening, a car is transferring to someone's name. And people need to remember that just because it's in the agreement doesn't mean that it happens. You still have to go out and make that change yourself.
That's a great point. Great point, Elise. So, let's discuss a little bit about, when somebody finalizes a divorce. On your end, when somebody finalizes a divorce, what happens? Do you take care of filing the parenting plan with the court? You take that piece and file it yourself, or does the client have to do that on their own?
I'm going to take you through the 2 hour divorce process from start to finish. So, someone comes in, either one person or two together. We send out a questionnaire to determine exactly what kind of documentation they need, whether it's a simplified dissolution, a dissolution with property, a dissolution with children, a paternity, or a modification of some type. After they've done that questionnaire, then they're going to schedule their mediation and they can have as many mediations as they need. Most people finish in 2 hours, which is why
Mhm.
I called it the 2 hour divorce, but they can do that 6 times over the course of 2 years if they want. They're on nobody's time schedule except for their own. It is their process. Once they're done with their mediation agreement, and that's going to entail the parenting plan and or marital settlement agreement, depending on their situation, then we're going through and preparing their documents based on everything that they've put in their questionnaires. So that gets popped into the documents. We then create an e filing portal on their behalf and file the documents on their behalf. if they've chosen the uncontested route, and depending on the county that they've chosen, they want us to follow the uncontested procedures for that county. So we're going to then do that. And we stay along with the case to just answer any questions they may have or see if they've received communication from the court, because remember, there's still pro se litigants in this process. And if anything else, anything additional needs to be filed, we're pretty much there just to hold hands until they get their final judgment emailed. And it's usually as painless as that. Really, the only, and I forgot, notarizations are in this too. So once we prepare documents, they're then
Mhm.
e-signing and meeting with our virtual notary to do that. The only waiting period is after you file, there's a mandatory 20-day window where if at that point, anyone can pull the ripcord and say, oh, I actually didn't want a divorce, but I've never seen that happen. So at that 20-day mark, then we're going to continue on with the uncontested procedures. And it's really great. I mean, there's a high success rate of people not having to have hearings. I would say 90%. Sometimes there's something odd that comes into play, like maybe they have child support through the Department of Revenue and there's an outstanding balance in arrears, and then the judge doesn't want to let that pass through without a hearing, but it's very rare. So in pretty much all pre-suit circumstances, they're going to be able to pass through and just get their final judgment emailed.
Nice. And it seems like a no-brainer to myself, right? It saves a
Yeah.
lot of time and saves a lot of money, especially when you handle everything from point A to Z with filing the stuff for the pro se parties. So on the estate plan side, similar. I mean, they should revisit the people that have separated or divorced, revisit to make sure that their wishes are written down as they would want them to be going forward. So that's always a good thing with my clients. For example, they have yearly reviews for anybody that does a trust plan with my firm. They have a free yearly review, and in some cases, they come in and say, "Hey, we're not doing too well, my spouse and I, and we're going to separate." So I'll give them some advice, and sometimes even send them to you as a referral to look at, taking care of the divorce.
Yeah, I know you and I pass a lot of people back and forth. And from what I remember, you do both prenups and postnups, right?
Correct, correct.
Okay.
So
Yeah.
that's something that is, I'm clear to the potential clients that, hey, estate planning is not divorce planning. Some people come to me up front saying, hey, I want to try to do an estate plan and leave as little as possible to my spouse. I said that's not what estate planning is about. That's where a prenup or a postnup would come into play. But keep in mind that the other party has to come to a compromise. It's not just, you can't do that on
Right.
your own and say, I want to cut this person out because, by state law, you can't disinherit your spouse, whether or not, even if they were, unless they're in agreement with it, of course. But in most cases, they need to have something left behind to take care of paying the mortgages or help raising the kids. So that's why Florida doesn't let you disinherit your spouse completely. You can
Yeah.
leave them a percentage, but not leave them nothing.
Hmm. I want to throw
So
out there too,
go ahead.
because I think a lot of people feel like if they have a prenup or a postnup that they can't mediate or they can't settle outside of court, and you absolutely can. So we get those prenups and postnups both coming in, and then
Mhm.
people can either choose to adhere to the entirety of it, they can choose to adhere to different clauses of it or to drop some clauses of it, or they can choose to just abandon it completely. So that isn't something that stops you or forces you to get your divorce done through the court. You can still do it amicably.
Amen. Now, if someone delays updating their estate plan, this is more kind of along the lines of my area. They delay updating their estate plan after a divorce. There's several problems that can arise. We kind of touch a little bit on some of them. So again, a lot of times people, just like when they do a plan, they can't predict the order in which the people are going to pass. I have several cases where somebody left the property to their child, and most of the time it's an adult child. I am very clear with them and say, hey, don't leave it to a minor. But within even adult children pass away sometimes before the parents do. So I had a crazy case to where somebody a, a divorcee, a man who owned the home on his own, added his son as a beneficiary to a deed and actually added him. It wasn't a ladybird deed, so I take that back. It was actually adding him as a co-owner of the property. Lo and behold, the son died, and now all of a sudden the gentleman is having to deal with his ex-spouse because the son had no will in place to say, "Hey, my share of the house goes to such and such or back to my father." And so all of a sudden, this gentleman, with no intent of leaving his ex-wife anything, has to deal with the ex-wife in a probate for the inheritance to be decided by a judge for the child that passed away. So that's one kind of a situation, and between you and me, I mean, it's almost like on a weekly basis that we come up with a new or hear of a new scenario we never could have dreamed of, right?
Right, right.
So
Just thinking, what have we gotten ourselves into? I mean, we have created everything that we do as a society. You and I have jobs because of things that have been created. I mean, it is how it is, so it's not going to change. But sometimes it's interesting to just take a step back and see that the world, this is just a construct.
yeah, yeah. And so my point to our viewers is that you guys have options out there. It's just a matter of making sure you're aware of all the options before making a decision. A lot of people feel like that they have to go through probate, and that's not always the case. Just like a lot of people that are getting divorced feel like they have to lawyer up or go to court to get divorced, and that's not always the case. You have to file stuff with the court, but you could go definitely to Serenity Family Solutions and seek, um, that mediation service that you provide and make things a lot easier on everybody.
Hmm. Yeah. I do want to say that sometimes mediation is not appropriate. It is not going to be appropriate to every single person.
Hmm.
We can still do it if there is a no contact order, if the target wants to have it done. But
Hmm.
I'm sending out risk assessments to every single person that's coming in mediation, and I'm looking for factors of potential suicide, homicide, coercive control, and interpersonal violence. And I'm seeing if there are any things that are elevated and also what can be done about it. So we're looking to see also, do they have coping strategies? Do they have a support system? If not, we're going to be sending people out to therapy or whatever it may be. If it's really intense, then we may have to, call the suicide hotline or something. But if there is a really high level of coercive control, we're of course going to make mediation safe. They can be in separate rooms, they can be in separate Zoom rooms. They don't have to have contact with each other at all if they don't want to, and the mediator can go back and forth. But if the level of coercive control is so high that someone wouldn't be able to consent to what they're talking about, just knowing that the other person is involved in the process, I have had to tell one couple mediation is not appropriate for them and that they need to go through court. That, of course, is going to be the minority of people, but just because I have that mental health background, I want to make sure that everyone is safe and comfortable going through the process.
Nice, yeah. Something that I didn't even think about. It's always pleasure talking to you because I get to learn new things every time we discuss certain scenarios. So, similar to estate planning, mediation is about communication and resolution. How can that mediation process also help parents make better long-term decisions for their kids, including, who should step in if something happens? Is that something that gets talked about in mediation as well?
Absolutely. Yes. So we're going as far forward as we possibly can. If, say, someone's coming in and they have an infant, it's going to be really hard to make a parenting plan that lasts 18 years. But that's one of the things that's beautiful about it is anytime there's a significant change, if they want to change it in the plan, they can come back and do so. So we're also putting in these clauses saying if an issue comes up that they can't agree amongst themselves, then they'll try mediation at least once before litigating. But in all honesty, the parenting plan is something that you create, you file it, and then ideally you never have to look at it again because you're able to co parent and be flexible and communicate with each other outside of needing neutrals. But we're always here if you need that. So people are sitting down if they're actually going through the process as they should, looking forward rather than looking at the past, They're going to be able to sit and think about, okay, well, when they start high school, which school are we going to go to? Or what's going to happen down the road as far as when my child gets married? What are we going to do about wedding expenses? So it's a nice time where people can actually sit and think about all these things without fighting.
So I'm gonna fast forward to the last topic just because we're running a little short on time. But for someone listening right now who's in the middle of a separation, what's the very first step that you'd suggest they take to protect their family and perhaps their future planning?
I suggest that people look into their options. I am a big fan of knowledge is power. I want everyone to be totally informed, and I want people to be in control of their own lives. I don't want to come in and tell anyone what to do. So you should look at the different options between, do you want to have a consultation with an attorney or 8 attorneys? Which one do you like? Do you need that consultation? What are your options as far as mediation, something like 2 hour divorce, collaborative divorce, arbitration, and just inform yourself on everything that exists out there so you have the power to go through your own process. That's what I really want. I want power to go back to the people, because if you fight a lot and you can't agree to anything, the more that you fight about, the more the judge is going to decide for you. If you can agree to those things, you can pass through beautifully, and then you are in control of the outcome.
Nice. Now, last but not least, at least for our listeners, could you share your contact information in case anybody out there is in need of those services?
Yes, of course. So our company is Serenity Family Solutions, and our website is serenityfam, F-A-M, like family.com. And on there, we have a chat bot. You can ask all the questions 24/7, and you can do your contact form, anything else you want to do there. If you want to call us, it's 407-377-7147. And if you want to email us, it's admin@serenityfam.com.
Thank you. Thanks for tuning in to Wills, Estates, and What Comes Next with me, Jamie Cuzmar. A big thanks to Elyse Salley for being here today. If you or a loved one need help with updating your estate plan after divorce, custody changes, or what comes next, visit kuzmarlaw.com to connect with me. Don't forget to like, subscribe, leave a review, and pass this episode along to someone who needs it. And I'll see you on the next episode. Thank you.
Thank you, Jamie.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.